Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine, and I'm here with my co-host, Alan Reinach, who is president of the Church State Council. We have embarked on an odyssey, I guess, to try to take back religious liberty from the political extremes. It's not easy, Alan.
No, it's not.
And today we're going to be talking about a case which I don't think is going to generate too much disagreement. When you get down into the nitty-gritty of this case, I think we can all agree that having your religious identity respected in any setting really is a fundamental constitutional right. So, Alan, why don't you go ahead and bring on our guests?
Well, friends, the Supreme Court is the gift that keeps on giving when it comes to religious liberty. We have a new case to talk about that the court will hear in the coming months. But two questions I'm going to pose and then introduce our guests. First, is religious liberty just for you or me or people who believe more or less like we do? Or is religious liberty for people of all faiths? What do you think? And while we're at it, what good is a right if there is no remedy? Our guest today, Steve McFarland, is director of the Law and Religious Freedom Center at the Christian Legal Society, a post he held years ago and has returned to. And attorney Todd McFarland, no relation, deputy general counsel for the General Conference of Seventh-day Adventists. Welcome to Just Liberty, friends.
Thank you. It's a privilege.
Great to be here.
So, Bettina, why don't you kick us off with the first question?
Okay, so let's start with the basics for people who aren't aware of this case that we're talking about today, which is about Mr. Damon Landor. So, Steve, why don't you walk us through the facts of this case and how it ended up at the Supreme Court?
Yeah, Bettina, Mr. Landor was incarcerated for about 5 months in Louisiana prisons. About 3 weeks before he was due to be released, he was transferred to another correctional center where he indicated to the warden and the officers there that the applicable law entitled him to avoid shaving his head because of his Rastafarian religion. And unfortunately, the police guard trashed the paper that Mr. Landor had handed him, demanded some proof that this gave him in particular a right to avoid the razor, and because he couldn't immediately produce a court order like that, they held him down and forcibly shaved his head. So when he got out of prison, he brought a civil action in federal court seeking damages both against the officers, both in their official and in their personal or individual capacities.
Well, Steve, I'm not sure all of our listeners are going to be familiar with the Rastafarians. Very briefly, what's the business about the hair for the Rastafarians?
Well, those of us who embrace the Bible as God's word should be familiar with the Nazirite vow. It's in the book of Numbers, chapter 6. And the Rastafarianism, I'm no expert, but it was developed in Jamaica in the 1930s. It combines elements of Protestant Christianity with mysticism and a pan-African political consciousness. It considers Emperor Haile Selassie of Ethiopia to be a messianic figure. Anyway, it's a different and minority religion, kind of a syncretistic religion, and one of the distinctives of it is that men do not shave or cut their hair.
You know, it really struck me, Todd, as I was looking through the amicus briefs that were filed in support of this case. a friend of the court briefs in support of Mr. Landor. It wasn't just Rastafarians, if any. It wasn't just one or two religious groups. It was a huge range of religious groups. I mean, you're representing the Seventh-day Adventist Church, World Church. Why get involved with a case like this?
Well, it really goes to the one of the questions Alan asked at the beginning of this talk, and that is, what good is a right without a remedy? So the issue here is not whether or not the state of Louisiana violated Mr. Landor's constitutional rights. They absolutely did, and they admit that they did. What they're saying, though, is that despite this, they should not be held responsible or accountable for this. They claim that, quote, we have put, this process in place so this can never happen again. I don't know if anyone actually believes that, but the issue is whether or not he is entitled to money damages for the constitutional injury he suffered. And, this is going to be important for several reasons. I do think he's entitled to be compensated for his injury, and he's probably entitled to get some money for that. But I think even more important than that is, without a threat of economic damages, prisons and prison guards and other corrections officials have absolutely no incentive to follow the law. They're never going to be criminally prosecuted for this, even if it was a criminal violation. And without a remedy, they will not respect the right in any way. And the state of Louisiana demonstrated that because they did violate his right, and now we're just claiming, well, we shouldn't have to pay for that.
Well, as someone who litigates cases, religious freedom cases, employment discrimination cases, I got to ask Steve, because, you've been in this field for an awfully long time, as long or longer than I have for sure. Why is the statute not clear in providing damages? Apparently, we're arguing over this because, whoever drafted this statute didn't make it really clear. And I've asked this about, some of the law professors who were involved in the Religious Freedom Restoration Act drafting, and this bill. I actually have some testimony in the congressional record from some land use issues that we were involved in back in the late 90s and all. But this is based on a bill that was enacted in 2000. So I guess, maybe the broader question is what led up to the passage of this bill, and how did the drafters manage to leave out a specific provision for proper remedies?
Well, that's a great question, Alan. In 1990, the Supreme Court devastated the law underlying the first 16 words of our First Amendment, and specifically the protection in the First Amendment for free exercise of religion. The court said, well, you know what? The free exercise clause doesn't even really have much to say if the burden that is being created by the government on your religious exercise is the result of a neutral application of a generally applicable law. Now, that's a lot of legal gobbledygook, but what that think in terms of a state law that prohibits giving alcohol to minors, and that law being misused to prosecute a priest providing the Eucharist to someone under 18. Ridiculous example, but it literally is what would apply there. And so the free exercise clause after Smith was left with virtually little, few teeth, if you will. So in response, 3 years later,
Well, and look at the facts of this case, Steve. In the facts of this case, you've got, a prison system that says, no, you can't grow long hair or dreadlocks, and had nothing to do with religion. It was just, they have grooming requirements that apply to everybody. So under that analysis, I don't think Mr. Landor would get to first base in court.
no, you're exactly right, and that's the problem. If not for a almost unanimous decision or enactment by Congress in 1993, 3 years after Smith, to create the Religious Freedom Restoration Act, and that restored state of the law before Smith. And the state of the law before Smith included the award of damages. And so, yes, the RFRA and the later law that a sister statute, the Religious Land Use and Institutionalized Persons Act of 2000, they both have identical language in their remedies, and they say appropriate relief against the government. Well, obviously, the RFRA, as we call it, and RLUIPA, as Mr. Landor was seeking relief under, both were seeking appropriate relief, and they were returning the state of the law to before Smith. So it shouldn't have been rocket science, in my opinion, for a court to say, well, Congress has decided that the law before Smith was right, and it has allocated appropriate relief. And what was appropriate relief before Smith? You could get damages for violation of your constitutional rights. So, in a perfect world, in hindsight, would have been great if they would have had a footnote that listed every type of judicial remedy that had ever been employed to defend our religious freedom, but they didn't.
But Alan, I think to go to part of your question is why didn't they do that? Part of it was the philosophy of both RFRA and RLUIPA, which was to be this very this very broad overarching bill that really put things back where the First Amendment was and didn't get into all these specifics and said, we're going to let the courts work this out. And of course, the courts did work it out for RFRA a couple of years ago. So I think it wasn't just that, bad lawyers or bad advocates were on this. I think it was done intentionally. And I understand the reason, and I'm hopeful the Supreme Court's going to do the right thing come this next term.
Well, this isn't the first case involving damages, is it? I mean, I think there's been land use cases where religious institutions have been awarded damages in the lower courts, haven't there?
So we're getting to very technical areas here. Let's be clear. But no, this is the first time for damages against people in individual capacity that have been held. So this is a matter of first impression for the Supreme Court.
So why don't we go into what you have argued in your amicus brief, Steve? Christian Legal Society wrote an amicus brief. General Conference of Seventh-day Adventists signed on to that. What was the thrust of the argument that you were making?
Well, briefly, four points. Number one, we say that both statutes, RFRA and RLUIPA, the 1993 and the 2000 acts of Congress, they're sister statutes and they should be read harmoniously. The language is almost identical. Second, we say, hold it, the Supreme Court has already interpreted RFRA with identical text to include damages or allow for damage suits under RFRA against government officers personally. So shouldn't that be applied to the sister statute, RLUIPA? And third, just as with RFRA, RLUIPA, as I said earlier, was intending to reinstate the law as it was before that disastrous 1990 decision in Smith. And so the state of the law back then, before Smith, was that it allowed damage suits against public officials when they violate federal civil rights. And then the fourth argument is that, you know what, damages are the only effective relief for cases where the harm has already occurred. Mr. Landor's dreadlocks have already been cut off, and where the victim is already out of prison, so there's no court order or injunction. That's going to be moot. So there's no other relief that can be afforded to Mr. Landor. So these prison officials get away with impunity unless the Supreme Court reads some common sense into the RLUIPA statute.
So unfortunately, we've lost Steve, but we hope he gets back on. Until then, Todd, you're the one in the hot seat, so I can ask anything I like. But my question is this. Let me play devil's advocate for a second. What would this sort of individual liability on the part of prison officers for acts such as this, the threat of that sort of potential liability, what would that do for the hiring, um, the recruitment ability of of our prison system? I mean, surely it's hard enough as it is to get adequate staff for correctional facilities.
That is an argument the state of Louisiana made, right? There's two answers to that. First of all, they can do step one, which is not violate the law, right? All of us, if we violate people's rights in our jobs, can be held liable for that. Um, Second is by both collective bargaining agreement and other statutes and so forth, the prison, even though it's on the individual capacity, the prison is going to pay for this, right? The guards themselves are not going to have to pay for this. Only in the most rare examples where the government authority has just decided not to reimburse does that ever happen. And that's something that the prison guards, through their unions or through their action, can negotiate. So we're not really talking about some prison guard having to pay this out. But to the extent that is a chill on them violating people's rights, then good. Doctors get sued for med mal all the time. They have insurance. Why should a prison guard not be held responsible for their actions when it comes to people's constitutional rights? And let's make this very clear. Prisoners suing prison guards is a very hard thing to do. This is not something that they can just easily win. It really takes this kind of clearly established law, clearly defined thing. And again, as Steve said at the beginning of the show, the prison guard got the Fifth Circuit's Court of Appeals opinion and literally threw it in the trash. Like, how does this person even keep their job, let alone, worry about having to pay? So, yeah. So I don't think there's a real concern there. And to the extent there is a concern, they can avoid this by just following the law.
So, Todd, I'm thinking that there's going to be plenty of listeners who are like, so what? I mean, people go to prison, they lose, their rights, don't they? What are you talking about? They have constitutional rights. They still can practice their religious freedom. And why should we care, right?
So they do lose some rights, but they keep other rights, and their religious rights are those they keep, not unlimited. But this is a perfect example why, right? This gentleman had not cut his hair for his religious faith for decades. I'm not sure exactly when it started, but you can find pictures of him, and it was years. He's in prison for a short period of time, and they're going to cut his hair. Like, this is something that will affect him for the rest of his life. And yeah, he should be able to maintain that right. There's balancing acts when it comes to a person's right and the prison's rights. And the courts have decided that long hair is not something that the prisons, can prohibit. So yeah, that's why I think it's important. And again, if the part of corrections is to reform people, taking away their faith and their ability to practice religion does not further that interest. And so the penalty is being imprisoned, not having your faith taken away from you.
We've been talking about an incident which occurred to a member of a minority faith, someone whose faith practices are not well known to the mainstream of America. Um, do you think that it reflects a larger reality that protection for people of faith in America comes easier if you belong to a mainstream religion, something that's easily recognizable, familiar, that the more tangential, the more minority your beliefs are, the less protection in practice they actually receive?
It is absolutely, majority rights receive easier and better protection. I would also like to say, don't kid yourself. Prisons are notorious for taking away people's religious rights of all faiths, including majority religions. But yes, if we as a society, if half the country wore dreadlocks and were Rastafarians, it's very unlikely this would have happened. These sort of marginal edge, sort of religions, and I say marginal not to disparage the beliefs, but just ones that are not mainstream, absolutely have their rights impacted. And, a lot of times you just have to explain what the right is, where it comes from. And then people are also a lot of times concerned, well, are they just trying to game the system? And certainly there have been prisoners who have done that. But in this particular case, it's part of an established religion. This has been around for nearly a century. And he held this, belief well before he was in prison.
Hmm. You remind me, Todd. I've often had occasion to point out that judges um, are good at detecting religious fraud. So, the prisoner who says, my religion requires me to have communion with Dom Perignon champagne and eat filet mignon, they're not going to get very far with your average judge making that kind of religious claim. But I'll also add that it doesn't matter how mainstream your religion is, people of your faith are discriminated against in prisons, oftentimes by chaplains who may be of another faith, and they, will give preference to the programming and worship of their own faith.
Yeah, absolutely. We have cases like that right now we're evaluating. We had a case out years ago in Washington State where a gentleman was a Seventh-day Adventist, but was also Native American. And he wanted to practice elements of his Native American religion, faith, of his identity as a Native American, and Christianity. And he felt that these were compatible. And in fact, many of our Native ministries will see compatibility there. Not everything is. And there was a chaplain there who just did not buy this, right? Did not think he could have both, and just refused it. He went to court. The prison system overturned the decision and said he had to be allowed to do it. Yeah, and it shouldn't be up to some chaplain to just pass on the faith of another person.
So this case is going to be heard in October, I believe, and we should have a decision early next year. Is that right?
I don't believe it's been set for argument yet. Um, we don't have the argument calendar yet, but it'll be this fall.
It'll be this fall. Okay, so let's assume that this decision goes Mr. Landor's way. What do you hope, Todd, comes out of this, both in terms of reform of practices and protocols in prisons, but also, I guess, how the average American looks at religious freedom claims in institutional settings?
I think hopefully prisons, and I do think a lot of, despite what Louisiana did, there are prisons out there who follow this. Um, and so I hope that reinforces that, and then prisons start to take people's rights seriously. It doesn't mean they get to run the prison. It doesn't mean that there aren't restrictions, but that they have to seriously engage on this. So that's what I would hope, would happen in the prison context. I think in the broader one, I hope people would understand that these rights are worth protecting. I will tell you, I've told the facts of this case to a lot of people, including people who may not initially be very, sympathetic. But the idea of holding a guy down 3 weeks from getting out of prison and shaving his dreadlocks off when their court said you can't do that, like even the most hostile people to religious rights in prison, like, wow, that's not a good thing. So I hope people understand that, these prison guards and prisons need to, listen, ironically, the people that they incarcerate are there who broke the law, right? And if you're there to reform them, shouldn't you be the model of following the law? Not just like, well, no laws apply to us, we can do whatever we want. It is the height of irony that this institution, the state of Louisiana, feels like, Mr. Landor, he should follow the law, but us, yeah, we don't have to suffer a penalty and pay damages if we violate the law. I'm sure Mr. Landor would like that same grace extended to him on his drug conviction, right? Well, okay, I may violate the law, but I promise not to do it again.
Todd, thank you so much. And we thank also Steve, who had to leave us early. And we will be following this case with great interest. I'm sure we'll be back to talk about it again. Thanks again, Todd.
Thanks a lot.
I asked the question and had Steve McFarland give us a little brief about the Rastafarians, because I'm quite sure not everyone has the same kind of exposure to people of so many different religions than I do. Actually, Bettina, I had a Rastafarian client in my first
Oh,
job out of law school. I was doing landlord-tenant work in Brooklyn, New York, and I had a lot of fun getting acquainted with him. Part of their religion that I don't think Steve talked about was, the sacramental use of what they called ganja, more
mm,
commonly known in this country as marijuana, long
right.
before it was legal to do so. Um, but the whole notion of religious freedom for prisoners We have a bunch of cases right now involving the wearing of beard. Well, this isn't prisoners. This is actually prison guards, wearing of beards by prison guards. But um, yeah, we have seen no end over my years serving here in the Southwest, no end of calls for help from prisoners about not being able to have Sabbath worship or um, having their meals respected. I had a case for a Muslim in the last couple of years who was only served one meal during Ramadan. You know, he could get his supper and eat supper after sundown in the evening, but they wouldn't give him a sack breakfast that he could eat before sunrise in the morning. And so, that was what that case was about, was like, hey guys, this is pretty basic. You got to feed the guy. And so, you know, we may not be that sympathetic to people who are incarcerated, but I think if we're Christians, we should remember that Christ's love is universal, and that's part of our basic ethos is, liberty for the captives, as the Bible says.
And, it is when civil rights are endangered among unpopular groups, that's when civil rights are the shakiest. That's when they're most at risk. And really, we talk about principle and loving our neighbor and all that. It's also about self-interest. Because when I protect the rights of those whose rights are endangered, I am protecting my own rights in the long term, right?
Well, we are, but Bettina, if I could be a little self-aggrandizing here, you know, the work that we do as Seventh-day Adventists is fairly unique within the larger religious freedom community in defending the rights of people of all different faiths. We're not alone, to be sure, but we've often called this the lonely middle because most groups are defending a narrow set of rights and interests that are peculiar to themselves. And, there's nothing wrong with them doing that. But we're known. Part of our reputation as Seventh-day Adventists is our willingness to protect and defend rights of others. And it's not just about self-interest. Yes, of course, you can't have their rights. You can't have your rights without theirs also being protected. But um, it is something that's unique and something that I find our church members are proud of when I
Yes,
remind them of this.
agreed. Long may it continue.
Well, Bettina, we could say so much more about religious freedom in the context of prisons. But friends, we'll pick up another story next time. This has been Just Liberty, where justice and liberty meet. I'm Alan Reinach with Bettina Krause. Until next time, remember eternal vigilance is still the price of liberty.